Hello everyone. Today I will be talking about the recent verdict given by the Supreme Court in the case of Surendran versus State of Kerala. But before starting with this case, we will first understand what are these two sections which were dealt in this case. So these two sections are: first is 498A of Indian Penal Code and section 32 of the Indian Evidence Act. Section 498A deals with the cruelty. So, any husband or relative of a husband subjecting the woman to cruelty will be punished. So, any person, it can be the husband himself or any relative of the husband of a, and if they are subjecting the woman, the wife of the husband to any kind of cruelty, then they will be punished. The husband can also be punished as well as the relatives who are doing cruelty with her will be punished for an imprisonment for a term which may extend to 3 years and shall also be liable to fine. The second section which is in consideration in the present case is section 32. Section 32 of the Indian Evidence Act lays down cases in which statements made by a person who is either dead or cannot be found is relevant and can be relied upon as a evidence. Now, in this section 32, its subclause 1 talks about the dying declaration. That is, it states that such statements are relevant when it is related to the cause of the death of that person. And it is also famous as a section related to the dying declaration. Dying declaration or such statements basically are those statements which are made by a person just before their death, and that statement is related to the circumstances which resulted in his or her death. Now, in the present case, this present case is the result of an appeal that was made against the decision of the Kerala High Court, which acquitted the appellant, that is the husband, for the dowry debt under section 304B of the IPC, while confirming his conviction under section 498A of the Indian Penal Code and sentenced him to rigorous imprisonment for 1. Now, when this case went to the Supreme Court, the Supreme Court observed that the dying declaration of wife under section 32 subclause 1 of the Indian Evidence Act can be used against husband to prove cruelty under section 498A of the Indian Penal Code, even if he is acquitted of the charges related to her death. So basically, even if he has not done anything related to dowry death, but he subjected that woman to any kind of cruelty, then that person will be held liable for cruelty under section 498A. The three-judge bench who was hearing this case comprised of Chief Justice of India N.V. Ramana, Justice A.S. Bopanna, and Bhima Kohli. They noted that all this is subject to two preconditions. Now, what are those two preconditions? First is that the wife's cause of death must come into question in this matter. And second is the prosecution will have to show that the evidence that is sought to be admitted with respect to section 498A of the IPC must also relate to the circumstances of the transaction of the death. So these are the two prerequisites that should be considered before convicting any person under section 498A. So this was in short about this case, Surendran versus State of Kerala. I hope this video was helpful to you, and please do like, share and subscribe to my channel. In case you have any query in regard to legal matter or law exam, you can reach out to me on my Instagram ID or on my email ID. Link for the same is provided in the description below. Thank you very much.